All right, now that it is 2 o'clock, we will get the call started. Welcome, everyone, to the CIP All-Call. This is Christina Cooper with the Capacity Building Center for Courts. And we at the Center for Courts are very glad to have you all with us today. The purpose of today's call is to discuss in greater detail state implementation ideas and efforts around the older youth provisions of the Preventing Sex Trafficking and Strengthening Families Act, of course with a particular focus on the implementation efforts of courts. I think many of you who are on the call today were also on last month's call on this topic, and we're going to take a closer look at some particular state efforts today, as well as a couple other items. So first, I will start off with a couple of our routine requests. One is to make sure you're on mute if you are not a presenter speaking, so we can minimize the outside noise. So please put your phone on mute or hit *6 to mute yourself. Additionally, we will start with a icebreaker question. So please respond in the chat box at the center of your screen to share with the group whether you are an early bird, a night owl, or something else altogether. For example, I am something else altogether. I'm always tired now that I have a 3-year-old. I used to be a night owl, but now I have transitioned to another topic entirely. Right. Of course, the early birds are getting in first. That just makes sense. And thank you, everyone, for chiming in so quickly. As the answers continue to come in, I will move on to remind folks that we're going to continue last month's discussion of the overview of changes in the law based on PL 133. And we will welcome back momentarily Jenny Kempner of the Juvenile Law Center. Jenny's April presentation, the PowerPoint, and the issue brief on the topic that she produced with the ABA Center on Children and the Law are available as resources that you can download on the bottom right of your screen. And we will explain what the other resources are throughout the presentation today. So in a moment, Jenny will spend just a few minutes highlighting some material she wasn't able to touch on in detail in April. While she's talking, please answer the poll you see in the center sort of right of your screen, asking if you participated in last month's call. Have you applied any new implementation strategies or identified a new area of focus based on the information presented? So you can comment on that while Jenny's talking. Also, please feel free to send Jenny any questions in the chat box or, of course, live through your phone. So without further ado, I will turn things over to Jenny Kempner. And please, for other people, remember to *6 or mute yourself so everyone can hear Jenny quite clearly. Jenny?
Thanks, Christina. Can you hear me?
Yes, we can.
Okay, great. Thanks. And thanks, everyone, for inviting me back. It's good to have you don't always get a chance to, get to do a little bit of a recap or get to cover the things you didn't get to fit in the first time, so I appreciate the opportunity. What I wanted to just spend a little bit of time on is the material that was in the end of the presentation, Normalcy, which I think is so important and also helps kind of pull together a lot of the provisions, because I do think that one of the most important things to remember about the normalcy provisions is they're not just about activities, they're about kind of connecting youth with the community and with people that care about them, and often that can really help with achieving permanency. So this kind of hopefully will help integrate a lot of the provisions that are in the Strengthening Families Act. So I'm going to, Eva, can we go to the next slide? So I wanted to do a little bit in kind of thinking about the presentation last month, and also thinking about some of the questions and discussion that we've had with some of the participants since the meeting. The last call. I wanted to think about some of these provisions in a way that maybe you guys are thinking about them, which is thinking about what does the court have to do, but then also what can the court do, and what might be really helpful in making sure the changes of the law are most effectively implemented. And I think both of those and understanding the difference between them are important, because I know you are working with people where they do want to know, what do I have to do, but you also want to know in your head, what do I have to do, and what might make the most sense to do. So kind of the nuts and bolts for implementing the reasonable and prudent parent standard itself, some of this doesn't necessarily in the first instance, impact the court or have the court doing something. And I'm going to, if it's okay, remind people to have their phones on mute. I'm getting some feedback, but I hope it's not from our location. So Eva or anyone, tell me if you think it's from where I am. Okay, thanks. So in terms of implementing the standard, this is something that states must do throughout the system. And usually it's going to take the form of law or policy, letting caregivers know that now they're going to have the authority to make certain decisions. And then the Child Welfare Agency must also make sure that the standard is implemented system-wide, which means also in group care, and that caregivers are able to make the decisions and designated so that kids in all settings, not just family foster care, have access to the standard. And so this is also then going to look like a training requirement for caregivers. That's what's specific in the law. But in looking at the considerations for the court, I think, is going to want to make sure they understand how the standard was articulated in policy and law, so they know what the stakeholders and caregivers in front of them understand and what they are being told to do. And then I think in terms of the training, it is only the caregivers that are required to be trained, but I think that it makes a lot of sense for court personnel as well as other child welfare professionals to be trained as well, because again, you want the standard supported throughout the system, and you're really going to want to know what caregivers are being trained and what the expectations that are set are, so that the court can also reinforce those as well. And then an understanding that this really does apply to all settings, and that some settings it's going to be more challenging to implement the standards than others. So again, something that the court is going to want to be aware of. Excuse me. Next slide. Excuse me. The next provision is about liability and liability protections for caregivers. Again, one where it's more that the court will experience kind of the results of this policy, but wanting to be aware of it, particularly at the outset, that they might be having to inform some of the stakeholders and some of the people before them about these liability protections. Because as I'm sure you all are aware, one of the biggest barriers to youth having access to activities like their peers is this concern of liability, that if I say yes to something and a youth gets hurt, will I be sued? Or some of the things that systems have put in place to address this is create all these barriers or red tape so that you'd have to go to court or you'd have to get a supervisor's permission just to join a debate team. And so now states must have protections for liability for caregivers and also can address whether private entities have those protections as well. Those protections are going to be in state law, and many states already have those in place. But because liability has been such a barrier to normalcy, I think the court wants to be aware of what these provisions look like, and they might be the ones, potentially the first ones, to inform a caregiver, excuse me, I'm so sorry, or case planning team that they exist, because if this is something that is in the way of kids experiencing normalcy, the more that this information can be shared with caregivers and others, the better. Okay, next slide, please. And then here we're going to get to what's probably most important for you guys on the phone, is just kind of how is the court specifically required to participate in implementing the normalcy provisions. And again, the first two slides give you some ideas of what you might want to do, but here we're going to get to kind of some of the have-tos of what the court has to do. And so the law does require that at each permanency and status review hearing that the court is asking the agency to specify the steps that are being taken to implement the reasonable and prudent parent standard, and whether the child has regular and ongoing opportunities to engage in activities. Now, the law specifies that you need to do that for young people with a permanency plan of APPLA, but I think this is where the considerations in the policy and practices that you guys are considering right now, where you really do want to think about what implementation and effective implementation will really take. And so I think these inquiries, while the law mandates them for a specific group of kids with a permanency plan of APPLA, if we go back to what we saw in the first couple slides about the standard itself, standard exists throughout the system. And so it does apply to all youth regardless of placement and permanency plan. So do you want the court process to reflect that? So do you want the inquiry to be for all youth or just a small number of youth? The other thing to consider is, as we're looking at all these provisions as a whole, we're looking at these opportunities the court has to really establish a good rapport with the young person, as well as getting a good understanding of the caregiver and the situation and relationships that the youth is established. So this is a great opportunity, this inquiry, to make it really meaningful in the kind of rapport and relationship the court can develop with the youth. So I think that's another good reason to think about why making a choice to expand this inquiry to all youth can be a very powerful way to really create effective implementation. So I'm going to ask you guys, if you don't mind chatting in the chat box, to answer the question of, where you are at in implementation with respect to kind of the scope of this court inquiry. And so it would be great if you could chat in the chat box if you are planning to implement the normalcy inquiry for all youth, for youth of all ages regardless of permanency plan, for just youth with the plan of APPLA, or if you're not sure yet, you're still discussing this. It'd be great to see kind of where you all are with that.
And while people are typing in, I'm just going to make another request for people to mute their phones. If you have a smartphone or an iPhone, please mute that the way necessary for that phone, and otherwise hit your mute button or *6 because we are getting feedback from a participant. So thank you.
Thanks. Well, it's good to see we're getting a couple of responses that we're implementing it for all youth in care, or not sure, but hoping for all youth. And I think what will be great to hear in the next couple of months, and you guys can use this forum for, is to hear how that's working out, because I think you will have examples of states like Pennsylvania. I know Sandy Moore's going to discuss more what's happening in Pennsylvania, of what it looks like, and the degree to which it's doable, but then also if it's really benefiting practice and also maybe benefiting outcomes. But it does look like we're getting a good number of, still discussing, but also that we want to do it for all youth, part of a judicial and education checklist. So that's great to hear. But again, I think the most important thing is just to be that you guys can do is you can bring that conversation to your jurisdictions and talk about the pros. And I don't know if there are cons. The cons might just be that it's an additional finding, but I think there's a lot of good reasons for it. But I think at least having the conversation at the very least brings the topic of normalcy and the importance. So you can use it, I think, as a great opportunity to educate and share a lot of the information you guys have and are learning through this forum. Next slide.
Sure. And Jenny, in the interest of time, perhaps there's just one more slide to focus on before we move on. Thanks.
Yep. Sure. And so this is kind of our second to last, but we will conclude, is just looking at, I think that the role of the court for implementing the normalcy provision is so important, but I think that you will need to kind of guide your court, because it is asking the judge to take a different role. We have a lot of judges who are very committed to normalcy, but the response so far, given the way the status of the law is that they will order that things happen. They will order that a youth gets to play softball. They will order that they get to take a trip or authorize that. And what we really want to move to a system is where those decisions are being made by the caregiver, by the team, and the whole reason we have this in the law is that we want to normalize those decisions so that they can happen in the context of the youth's daily activities. But so what does that mean for the court? Because we really do want the court to be modeling kind of what normal is for youth. So what is that going to look like if they're not kind of micromanaging these decisions about normalcy? So I think it is about setting the expectations that we think access and experiences are good. Obviously, the decision-making is individualized for every youth, so it's not every youth gets to do everything, but that we do think it's good that youth in care get to have opportunities similar to their peers. I think modeling kind of a collaborative approach about decision-making that includes the whole team and the youth, but also is going to include the biological parents, and thinking about how that's going to work, even in cases where the parent may not have the final decision-making authority, but where it's a good thing to include them, making the connection between normalcy and permanency, that it's not just that we think it's good for kids to play on sports teams. I think we do, but it's not just that, but that we think it's good that they have connections and skills, and that's good for them for growing up, for the transition to adulthood, but also for potential permanency options. And then maybe most importantly, from a perspective, and I will admit as a lawyer and advocate, is that we do need the court to be identifying and eliminating barriers, because this is a big switch. This is a big culture shift. And so while we don't want the court micromanaging cases, what we do want the court to do is be looking at what is happening in the case and helping identify barriers and eliminating them. And if you can go to the next slide. Some of the barriers that I think, you want the court to pay special attention to, and ones that kind of we've seen as are ones we just want to address and really help people be equipped to handle, is really, seeing how kids in group care, how they're faring in terms of access, and seeing if additional provisions or services or supports need to be put in place to make sure those kids have access to these activities. Kids with disabilities, we do want to make sure that they're not eliminated or, ruled out from activities because people are more fearful of their exposure. And I think that's a particular area the court can play a great role in helping people understand that any individual, including a young person with a disability under the ADA, can get special accommodations. And that's something that the team might need help understanding that they can do to reduce risk and also, but help promote access. And also LGBTQ youth. We want to make sure that those youth have access to the activities to the same degree as their peers, but also if their caregivers need special training or assistance in finding resources, that they have that support. So eliminating barriers doesn't always mean ordering payment or ordering transportation. Eliminating a barrier could mean that you are ordering or asking that a planning meeting occur, or you're asking that the agency help a caregiver find out what LGBTQ resources are in the community. So I don't want to say that every barrier has to be the judge, laying down the hammer and saying, do this, do that. It can just be helping people understand that the approach is we have to reduce barriers, and sometimes those barriers are going to be, at least in the beginning of implementation, addressed through helping people with knowledge. And so if you can quickly, and I promise this is the last thing, Eva, just show the page 5, the kind of bench card snapshot we have. One of the tools that we did in this publication was to give the court some ideas of questions that might be helpful for them to think about or ask as they're trying to identify and eliminate barriers. And so if this is helpful, we invite people to use it, but also feel free to modify it. But we were trying to at least early on identify some of the things that were common barriers and give people some ideas of questions that might help them pinpoint them. And again, with the goal of not ordering and making people do things, but really of making people adjust their thinking of what do we need to do to promote access and more opportunities for kids. Okay, and with that, I will close.
Thanks so much, Jenny. We appreciate you providing additional implementation strategies and ideas. And now we will switch over and hear next from my Capacity Building Center for Courts colleague, Christopher Church, who will talk to us about some relevant data and what to do with it. Chris?
Thank you. I just, as we transition into hearing from some of the states, we just wanted to share a little bit of data. This is from the 2014 AFCRS file. And what we're looking at here is the percent of children that are sort of those older youth that are legal orphans. How many of those children are we moving towards permanency? So what the chart shows is just the percent of older legal orphans achieving permanency, those that were in care for at least a year on their 16th birthday. Legal orphans, how many did we move to permanency by their 18th birthday? And then you can kind of see in the narrative up there, what it doesn't show is that we are doing particularly well achieving permanency for this particular population. This is certainly a population that presents challenges and needs specialized strategies. But we have a lot of work to do. As you can see in the chart, West Virginia is our best performing state, moving about 2/3 of those children to legal permanency before they age out. But you can see our next best cluster of states is hovering right around about 1/3 of those children moving to permanency, where most of our states are really clustered around that sort of 8 to 12%. So of legal orphans that are in foster care for at least a year at their 16th birthday, how many did we move to permanency by the age 18? And most of the time, it's right in line with the national rate, around 9.3%. So one of the things we certainly don't have time to really dig in deep here, but one of the questions that you'll see up on the poll, I see a couple of folks have already answered, is this a topic that would be of interest in discussing sort of in greater depth as part of the constituency group that's being launched right now related to APPLA and older youth? And then also we were sort of thinking as we transition, if you have thoughts about how the court can promote permanency for these particularly vulnerable youth, and you have specific strategies, we'd love to have you type those in the text box as we sort of transition into our next slide. But I'll go ahead and stop there. It's a complicated measure, and we recognize that, but there's a lot of reasons for that. It's really technical. And I'd certainly be happy to answer questions by email or in the chat box as we transition to our next set of presentations. But I'll go ahead and stop there. Thank you.
Great. Thank you so much, Christopher. And this is Eva Klein, also from the Capacity Building Center for Courts. And if you have any questions for Christopher or anyone else regarding the data, something you want to share, please put it in the chat box, and we'll try to answer during the call. And we're going to move on now. I'm just going to leave this up for a minute while I talk. We're going to follow up with some of the context that we just heard. So our showcases are going to focus on what's happening in 2 states, Pennsylvania and Nebraska. And we'll hear from your colleague Sandy Moore, who's the CIP director from Pennsylvania, and Katie McLeaf-Stevenson, the CIP director from Nebraska, who is joined by Sarah Helvey, the Child Welfare Program Director at Nebraska Appleseed. And as you listen, please answer the poll about any similar implementation activities you may be pursuing. And remember, you can ask questions in the chat as well. Sandy?
So thank you very much, Eva. Just to put some things in context, I've been the SIF administrator for the past 8 years in Pennsylvania. We have about 15,000 youth in care. We have 60 judicial districts, 67 counties. We have 2 large, Philadelphia is our largest county. Pittsburgh and Allegheny County is our next largest. And then we have, some pockets of centralized cities, but most of Pennsylvania outside of Philadelphia and much of Pennsylvania is pretty rural. We have about 140 judges at our trial court level that hear these cases, and about 50 hearing masters or hearing officers who are judicial officers who hear the cases and make recommendations for the judge's approval. So just so you have some sense of Pennsylvania and how it matches up with your own state. But one of the things when I was thinking about our work with normalcy and APPLA, and those are the 2 pieces of the law that I was asked to talk about, is that for us what's been extremely helpful is that our Supreme Court is very, very supportive of the work that we're doing, and our Justice Liaison, Max Baer, has been incredibly supportive, and you can see in the comments that he's made, and he's very involved in the day-to-day operation of court improvement in Pennsylvania, which is a really good thing for us. Then we have the work that we started doing around normalcy and looking at APPLA and actually congregate care in our state really began back in 2011. Our state roundtable is our SIP advisory board. They meet once a year. We have a structure that includes local roundtables and leadership roundtables, and ideas or concerns from counties and local court jurisdictions flow up to our state roundtable advisory board from those local and leadership roundtables. And the issue of older youth and what was happening in Pennsylvania with older youth came to the state roundtable back in 2011. And as they do with most issues that they agree upon, they created a work group. the statewide work group, we almost always have a judge, trial court judge from one county and a children youth administrator from another county co-chair those groups. It's all voluntary, so all the members volunteer to be part of it, and it's just if the topic is something they're interested, then they choose to be on this work group. This particular work group has lawyers. Actually, Jenny is on the work group, but it also has youth, and it has a number of other folks. And as you can see from his comment, Judge Shawley, who is a judge out of Union and Snyder County, the middle part of Pennsylvania, is very passionate on this issue. I can tell you if you ever want somebody to talk and try to convince your judges why this is important, Judge Shawley is the person for you. But our conversation really was evolutionary and a progressive process. When the State Roundtable created the work group in 2011, they really said to the work group, we want you very specifically to look at successful transition to adulthood of our older youth. Well, when the work group started exploring that issue, it led to a conversation around APPLA and the use of APPLA and what happens to youth when they get that goal in our system. And that then led to conversations around congregate care. Then that led to conversations around youth in court and youth needing to have a voice. And then that naturally led into conversations around the youth's experience while in care. So we had data that could tell us the number of youth who were in care. We didn't have data that could tell us what was their experience like. We had anecdotal kind of stories. That work group has put out 4 different reports, and they're all posted on our website, and there they are. I'm not going to go into much of the detail. I'm going to keep referencing back to those reports on some things. So if you would like more detail, they're all there for your access. So where did we begin? We began with a very focused purpose task back in 2011, very strong, passionate, committed leadership. Work group with members from really different disciplines who cared very much about this issue. Youth involved in the discussion, the planning, and actually as members of the work group. And we started looking at our data, trying to unpack our data, and trying to figure out who the kids were in our system that we needed to really pay attention to. As you all know, in 2014, President Obama signed the Preventing Sex Trafficking and Strengthening Families Act into law. In early 2015, our state children youth agency pulled together a very, very large committee, about 130 people, to look at both areas of that new law. And we actually divided into a group that looked at the sex trafficking pieces and then a group that looked at the other pieces. So that work started happening in 2015, but there were a lot of people who had already been involved in the conversation. And one of the things that we really knew that we needed to look at, having talked with youth and having talked about this issue for 3 years, was this issue of normalcy and what was the experience like for youth. And here's, one of our young people said, you adults make lots of plans and think you're doing the right thing, but, you really got to talk to us because we might be young, but we have lots of experience. One of the sort of undergirths or beliefs of our SIP process is that the people who are impacted by the change that we're trying to produce have to be involved in the creation of that change. So it was really important for us to have youth on this work group, but we also know our work groups meet during the day, and usually in Harrisburg. So we had to figure out other ways to get youth voice than just having them come to a meeting, and I'm going to talk about that in a little bit. So we had been having this conversation about APPLA, and we were sort of struggling with the concept of, how should we use APPLA? And I have to tell you, there are judges and administrators across the Commonwealth who felt very strongly that there were very appropriate cases for APPLA, and others who felt as strongly that APPLA should never be used. So when the president signed in the new law, many were wondering in our state, did the federal law go far enough? Should we not have APPLA at all? Or if we got rid of APPLA, would it just become a disguised practice under some other goal? So we were really sort of struggling with those issues, and what we came to decide is that while we did have it, we were going to try to make it the most difficult permanency option for a court to order. So our law, our procedural rules, and hopefully our practice make ordering APPLA a very challenging thing to do. And I just threw this in because that's where we started on prudent parenting, and this call isn't about prudent parenting, but we did move past that. And that actually is in our law. But the first thing we did back in 2011 was look at our data. As I said, our 2012 and 2013 reports have a lot of data in them, so I'm only sharing this tiny piece of it. But back in 2010, 50% of our dependent youth that were 13 and older were in group homes or institutions. And of the youth who were in those placements without a goal of reunification, the majority of the children had a goal of APPLA as their primary goal. And that was really a little bit concerning for us. And again, one of the other pieces about our data, most recently, as we were looking at this issue in our Department of Human Services larger work group, we compared their data to our court data, and there were really some differences in the data. And that's one of my points later is don't get lost in the data, because you can get lost in trying to make sure that it's perfect. And data's never, well, at least in Pennsylvania, data to date has not been perfect. But one of the things that came out, so we had some numbers. We knew how many kids. We knew where their placements were. But what we didn't know was what their experience was like. So we actually created a youth court survey, which really was focused on how much of a voice do they have, are they attending court, and what that looks like. But then we also created a process to look at our congregate care placements, and within that we asked about what types of activities, as Jenny was saying, it's not just in regular care, but in group care, especially what kind of activities and opportunities are those youth getting. And then one of the things we discovered as we were doing all this is that the youth that we talked to really, they knew they had an attorney. In Pennsylvania, typically as a guardian ad litem. They can have both, but typically it's a guardian ad litem. And, but they didn't really know how to use that attorney as we were talking with them. So we actually stole from, I think it was the state of Washington, who had created a really neat brochure for youth on how to work with their attorney and what their attorney's job was. And we created that document. It's actually going to our state roundtable tomorrow to get approval, hopefully, and then we'll be able to distribute it. So where are we? We were doing all that work. So here we are in Pennsylvania. I think I responded earlier that our normalcy laws, our statutes apply to older youth and to actually all youth in care, in any type of care. And we really, as we were thinking about that, we thought, how difficult is it going to be for a judge or for a caseworker to think, well, this child's 15 and a half, so I really don't have to think about, activities for a 15-and-a-half-year-old, but in 6 months I do, and it just seemed kind of silly. As we all talked, we said every child ought to have opportunities for activities like children who aren't in foster care and opportunities and connections, as Jenny mentioned. So what we now have, we have a statute that requires normalcy for all youth in foster care regardless of their age, standard for prudent parenting, liability, what Jenny is talking about, we really struggled over that one and got a pretty stringent liability portion put into our law. Training expectations, limitations on APPLA, a requirement for permanent connections for youth, and a whole bunch of judicial findings and orders that have to go along with that. We actually also have created juvenile court procedural rules, and our rules were done probably in about 6 to 8 months, which is lightning speed in the state of Pennsylvania to get rules processed, because we have to create them, post them, get all the revisions back, make revisions, send them to the Supreme Court, and hopefully the Supreme Court adopts them. But our juvenile rules require findings from our court on specific to normalcy, prudent parenting, and the use of APPLA. They also require findings regarding the agency's efforts to identify and support permanent connections. So not just to identify them, but what are you doing to support that, those connections staying strong? Reasonable efforts around conducting family finding, which is a different law that we helped get passed a couple years ago. And our rules got very specific that we just didn't want to say that, oops, sorry. I don't know what happened. I think I bumped something. I don't know what's happening. We didn't just want our rules to say that that all the other goals weren't appropriate and now you're going to APPLA. We wanted for each one a compelling reason to be stated by the judge. And then specific for children who have a goal of APPLA, we made it very clear in our rules that the judge or hearing officer has to speak directly with the youth. And that link takes you to our procedural rules. And this is why, because we, sort of our mantra is and Judge Shawley is really strong on this. A judge can't learn anything from an empty chair. You have to have the child there to talk to them or the young person there. Our court orders have very specific language for each of these judicial findings. The documents are contained in our statewide CPCMS dependency module, which has all of the orders that we use in dependency court. And what this does is it will allow us to pull data on these different elements. And this link will take you to where our dependency court forms are if you want to see that. The next thing we did is we created a set of training videos. The first is a video of our Children's Summit where we had youth and attorneys, and Judge Shawley actually led that panel talking about their experience and the whole issue of normalcy at our last Children's Summit in 2014. Then our court improvement program, along with our administrative office of Pennsylvania courts, created a video on normalcy. The video is geared towards judges and hearing officers and lawyers, although it's very appropriate for caseworkers too, but it was really telling judges they have a new job. And part of that new job and that new responsibility is making sure kids are being connected to healthy adults, and that they have normal activities like their peers. And then we had a group out of one of our mid-state high schools called the Tolerance Troop create a couple of scenarios where these kids pretended to be foster parents or foster children and showed the kinds of things that could happen that were very not normal situations. And then our work group created a discussion guide to go along with this 3-set video, and we distributed that to all of our judges and all of our children youth administrators. It's posted on our website so that they could use that set of videos when they were trying to train local lawyers or have conversations with children youth staff or just locally in their county. And then we have our CPCMS data and system, and we were able to pull out of that system the names and docket numbers for every child who had a goal of APPLA by age effective January 1st, 2016. And this is really helpful because our agency has APCARS data, which is really great data, but that was from September of last year. Our judges wanted to know effective January 1st who were these kids in their system, and we were able to pass that out to every county. And this link takes you to our data dashboard, which is a public dashboard. Two other things that we have. The one is going to our state roundtable tomorrow for approval. Our work group created draft contract language for counties to put into their contracts with service providers who provide foster care services or group home services, because in Pennsylvania, one provider could end up having contracts with multiple counties, and they could have multiple expectations coming from those counties. And we're hoping that we can have one expectation so that we don't drive the providers kind of crazy either. The other piece on here is that in the legislative bill in Pennsylvania that helped us conform to the federal law, our legislature asked our Department of Human Services to pull work together to study how we're using APPLA in the state of Pennsylvania and to provide recommendations to the General Assembly. That report was provided. I think it's one of the handouts for you. But the work group included me as the SIP administrator. It included some judges, a bunch of lawyers who work in this field, plus a lot of other people. But we decided that our recommendation would ultimately be to eliminate APPLA as a permanency goal for all children in out-of-home care by 2021, and there are a whole lot of ways that we're going to get to that. So finally, what's next for us? Lots of education, including a future summit presentations, and the work group wants to create a training video on teen behavior, what's just regular teen behavior. Court observations, my staff goes out into all of our counties and observes court and that's where it's so critical because that's where the rubber hits the road. You know, if we're doing all this work but nothing changes in our practice, then, you know, we've got more work to do. So that we gather data and we'll be looking at kids in court and what's happening around these issues. Our CPCMS court data will be able to pull out data on all of these elements. We have an APPLA tool that was created by our work group that, again, is going to our state roundtable tomorrow. And if it's approved, we'll be sharing that with all of our judges and hearing officers. And then our court survey for youth continues to stay open so that we can get that kind of information from all of people. Finally, lessons learned. I think for us, I put up here, start someplace. The new law is a good place to start.
The number you've dialed is not in service. Please check the number and dial again, or call 777-7000 for operator assistance.
I thought, oh my gosh, did I just lose myself?
Sorry,
here?
Sandy. I'm sorry. We're working on it. Apologize.
That's okay. So, we just said interest is a good place, but build on what you already have. And for us, it was interest. We started because a lot of people got very interested in this group of children. Figure out what you know and what you don't know, but don't be held back by the stuff that you don't know. We didn't know a lot when we started, but we figured out how to get there. Get the people in the room who care about the issue. We have a lot of different work groups, and we let people self-select into where their passion is. Get the voices of as many youth as you can in as many different ways as you can, and then figure out something to do and just do it. Do something, and then measure, did it work, and revise it. And Jen did not pay me to put CQI in there, but that's really what that is. So that's it.
That's great. That's fantastic, Sandy. Thank you. It's obvious that you've done so much great work in Pennsylvania. And I just want to remind people, if you have questions for Sandy, please enter them in the chat, and she can answer them. And we're going to also now hear from Nebraska. And so I'm going to turn it over to Katie and Sarah.
Sure. This is Sarah Helvey, and I think I'm going to kick it off. I just want to say thank you for inviting me. It's always an honor when I have an opportunity to co-present with Katie McLean-Stevenson, our Court Improvement Director here in Nebraska. We really have appreciated their partnership and leadership with court improvement on this issue and many others in Nebraska. So our legislative session just ended last month, and our legislature passed a bill, LB 746, really to implement the Strengthening Families Act in Nebraska, both to reconcile our, thank you, whoever's moving that forward for me, to reconcile our state statute with the federal law, and then also to implement a set of stakeholder recommendations for how we can maximize the SFA as a result of a stakeholder process that happened over the course of last summer and this fall and is continuing ongoing, and that's the piece that Katie will talk more about next. In your materials, there's a copy of the final version of the bill and a fact sheet, but I'm going to just focus on a few of the judicial oversight pieces that go above and beyond the requirements of the federal law. So first, on the reasonable and prudent parent standard, the bill does require the SFA findings regarding the reasonable and prudent parent standard for all ages in permanency plans. So as Jenny talked about, not just for age 16 and older with a permanency plan of APPLA. So I would just reiterate what Jenny said in the last presenter as well. I think this is really an easy but an important thing that your state can implement, and I saw in the chat that some states have already done that as well. It's in our bill as part of our statute. I forgot to mention that this bill doesn't go into effect until July, till this summer, and so we are still in the process of talking about, in partnership with Court Improvement and others, how we can develop model orders and bench cards. So we just got the bill passed, and some of that additional work will be ongoing and is on our plate for the next couple of months. In addition, on the reasonable and prudent parent standard, the bill requires that HHS document in their court report the consultation with parents on a reasonable and prudent parent standard. So this is something that was really important to stakeholders, and we really wanted to balance the shift of some decision-making authority from the state agency to foster parents, but to make sure that we're respecting the role of parents. And so the bill says, to the extent possible, a parent shall be consulted on the child's participation in age and other developmentally appropriate activities in the case planning process, and the department shall document such consultation in the court report. So that, provides the court with some level of information about how that's being balanced. And then the bill also requires the department to document in their court report any barriers to participation in normalcy activities. And so that gives the kind of court HHS some accountability, and the court ability to provide some additional oversight there. The bill also gives the court oversight to address any barriers to normalcy. So the language here is that if the child, GAL, caregiver, or any party believes the child has not had access to age and developmentally appropriate activities, the juvenile court may make appropriate findings or orders to ensure the child has access. But there's also a statement in there that in making such findings or orders, the court shall give deference to the caregiver in making decisions within the reasonable and prudent parent standard. So this is really intended to remove barriers but not second-guess foster parents. We had a lot of really good stakeholder discussion about how to balance that. And then on notice of rights, the bill is specific that the notice of rights shall be provided to youth within 72 hours of placement, and then at every dispositional and review or permanency hearing, and it shall be provided in hard copy. So this was a result of youth input that they kind of like the hard copy. I think with young people, we assume they want everything like texted to them, but our young people said they like to have a hard copy and that they want, that repetition is good, that they want reminders, because sometimes you get a notice of rights and everything is fine, but then later it's not. So our bill is specific about that. And then this encourages three things, I guess. It ensures that they receive their rights multiple times, but it also assumes that young people are attending their hearings, so it reinforces that expectation. And then by youth receiving notice of their rights at their hearing, we're hopeful that this will hold everyone accountable and also encourage issues to be raised in court when needed. Okay, on pre-discharge documents, the bill includes a requirement that the court make a finding as to whether the child has received the required documents at the last court hearing before aging out. So we have what's called an independence hearing. It's kind of like a capstone hearing right before aging out. And so this ensures, again, that the court is checking in to make sure that's happening by requiring the court to make a finding about those pre-discharge documents, the Social Security card, the medical records, driver's license, et cetera. And then on youth involvement in case planning, the bill requires that the transition plan document the efforts to involve and engage a child in the development of the transition plan, and that the court ask the child about his or her involvement, and then also, again, make a finding regarding the child's participation in the development of his or her case plan. And then finally, LB 746 is specific that the court must determine that the agency has met the SFA APPLA documentation requirements before approving a plan of APPLA. So these are the requirements that the privacy plan identifies significant supportive connections with identified adults, and the agency document the intensive, ongoing, and unsuccessful efforts to reunify or find a relative guardianship or adoptive placement for the child. So again, this just provides oversight to make sure the state agency is identifying those supportive connections and documenting them, again, before the court approves the plan of APPLA for young people aged 6 and older. And then finally, maybe one of the oversight provisions that I'm maybe most excited about as part of this bill is some changes that it makes to our GAL statute. There was some discussion among stakeholders about the roles of GALs in making sure that the SFA provisions happen and that they happen in a meaningful way for young people. So the bill requires the GALs to report to the court as part of their court report regarding compliance with the Nebraska Strengthening Families Act, or with LB 746. And I will say this was originally a more detailed report where GALs were required to report on specific aspects of the Strengthening Families Act, but a number of GALs were concerned that was too cumbersome, which was a little disappointing to me as a fellow attorney, but we were able to address it by kind of simplifying that requirement through an amendment so that they're giving some report to the court on and checking in with young people about the compliance with the Nebraska Strengthening Families Act. So with that, I know I blazed through really quickly due to time, but I'll turn it over to Katie, and if you have any questions for me, please feel free to type them in there, and I'll keep an eye on it.
Thank you, Sarah. This is Katie McLeese-Stevenson, and I serve as the Director of the Court Improvement Project in Nebraska, and will have been in the position 1 year on the 1st of June. I'm going to address a little bit about youth and community involvement as it relates to the Strengthening Families Act. But first, I want to have a special thank you to Sarah and also to Senator Kathy Campbell, who really were the leadership in moving the legislation forward and in a lot of the backbone work that's happened here. And Sarah's organization, Nebraska APPLA, along with the Nebraska Children and Families Foundation, have really done a lot to help facilitate this process. So while the legislation was being drafted, there was a group of people who were getting together from across the state, and there were 2 full-day meetings that were held with about 45 or more individuals, including both young people and stakeholders, to both learn about Strengthening Families Act and also to create an initial set of recommendations. And then throughout this process, there were over 300 young people and other stakeholders who were able to provide input. Following that, and during that process, youth voice, as was mentioned by Sandy and also Sarah, was identified to be critically important. And so focus groups were held, and this was facilitated again by Nebraska Children and Nebraska Appleseed. And like Pennsylvania, we have a couple of urban centers that were very rural, and so it was important that those were held in geographically diverse locations. And one was actually held at our Geneva Youth Rehabilitation and Treatment Center for females who have had law violations. I just did something where I got rid of the slides. Okay. I'm going back to them. Okay, thank you.
Okay, we're heading back. You can just keep going.
All right. Could you move to the next slide? I seem to have taken that ability away for me. Then we had parental input was also very important. And so through our Nebraska Federation of Families groups across the state, we had focus groups where parents were involved. Next, we wanted to reach out to foster parents. And the foster parents, we have a Nebraska Association of Foster and Adoptive Parent Association, and they were helpful in reaching out to foster parents, and we received their recommendations as well, and that was done through a survey process. We then reached out to other stakeholders across the state, and Nebraska Appleseed developed a survey, and that reached out to over 200, next slide please, over 200 stakeholders. And those that completed that are listed here. But as you all know, it's really important to have all the court stakeholders that are involved with this kind of a process. Following that, we were able to take the recommendations of the over 300 individuals. And on the next slide, it'll show you that those really came down to three main areas, those related to the reasonable and prudent parenting standards, youth notice of rights, and truth planning. We have in Nebraska, on the next slide, the Nebraska Children's Commission, and they provide recommendations to the legislature, and it's independent of the three branches of government. And in December of this year, they created the Strengthening Family Task Force. The next slide is going to be difficult for you to read, but hopefully at home on your computer you can blow this up a little bit. But it gives you a schematic of our structure. And so we have a steering committee, we have the task force, and then we have our subcommittees. So I'm going to touch briefly on the various subcommittees that are representative of the Strengthening Family Task Force. So the first one on the next slide is the Community and Family Voice Subcommittee. And that group is co-chaired, if we could go to the next slide. Thanks. Co-chaired by a young woman who's an alumni of the foster care system and a current another person who's a current foster parent. And we have involvement in this group of parent organizations as well as a variety of other stakeholders. And right now they're working on developing methods to seek youth input statewide through surveys and focus groups regarding the Youth Bill of Rights. This group meets in the evening. Young people are actively participating, and those that are parents bring their own children, and staff do as well. The next group shown on the next slide is the Grievance Subcommittee. And that is co-chaired by our director of the Foster Care Review Office and a member of our Inspector General's office. And so we've talked about you really can't have a Bill of Rights without a process by which to indicate that these rights are not being upheld. And so the Grievance Committee is taking a look at new and existing processes and also thinking about cultural issues related to this, and developing the appropriate kinds of response and resolution for these issues. On the next slide, the next group subcommittee is the Normalcy Subcommittee. And this group is co-chaired by the director of the Nebraska Juvenile Justice Association and one of the assistant deans at the University of Nebraska, Omaha. And they're really taking a look at how to establish normalcy for youth involved also in the juvenile justice system and mental health system and across all levels of care. This group has taken a look at how do we ensure normalcy for young people who have identified as LGBTQ. How do we create normalcy for young people that are also parents themselves? And so this group has a very wide scope, but I think is getting into some really interesting discussion at this point. The fourth subcommittee, which is reflected in the next slide, is the training committee, and that's co-chaired by our president of the local Nebraska Foster Family Treatment Association, and then I put the wrong acronym and then the chair of the Nebraska Association of Homes and Services for Children. And they developed to start off training that is for providers, particularly in congregate and foster care settings, about this work, and then really are going to be helping to do training across various systems. The fifth and final subcommittee of this group is human trafficking, and their work, we have another group that through our Attorney General's office that's working on human trafficking issues. So the work is coordinated between these two efforts. But this group is really looking at focused on youth who are missing from care, and we talked about that term instead of runaway youth, and especially knowing the propensity of children once they become missing from care to be propositioned to be involved in sex trafficking and the number that happens for. And so really trying to take a look at what are youth going to and what are they fleeing from. So next steps, these subcommittees are meeting, and I just stepped out of the meeting where this morning the task force appointed the members who made application to the Children's Commission. So that occurred today, and then we'll be meeting as a larger group in July to review recommendations, and then a draft report will be developed in the fall for inclusion in the Children's Commission year-end report to the legislature for our upcoming 2017 session. So that's fast, but you can find our materials on our website. Thank you.
Thank you so much, both Katie and Sarah. I'm going to turn it over to Jennifer Rennie now.
Terrific. Eva, could you, great, thank you. So we are going to end the call on time, and I do apologize. We had a rather ambitious agenda. We will, on our first constituency group, talk about partnering with agencies. So we'll hear from Julie Breedlover, one of her colleagues from the Capacity Building Center for Courts, to talk about what they're doing with child welfare agencies and some of the efforts to bring agencies and courts together around implementation. So the final thing we want to do is a couple of polls, and also we would like to let you know that we will be launching a constituency group around permanency for older youth and reducing the use of APPLA. And we will start with the provisions of PL 113-183. So a couple of polls, and then I'm going to direct you to where the link to the doodle poll is for to get your feedback on when we should have that first constituency group call. So the first poll at the top, did this call give you new ideas for implementation strategies? And then the second one, did the call provide new resources and tools you can use? And again, I typed it into the chat box, but there is a list of resources in the bottom right-hand corner that you can download. You don't have to do it during the call. We will leave the room open. So when the call is over, you can peruse the resources and download anything that you're interested in, including the PowerPoints that have the links and the information that you heard. And then finally, the bottom screen, will you incorporate any of these activities going forward? And I see that people are completing that poll. Thank you so much. And then the last thing I'm going to say before I'm going to ask you to click on the doodle poll, which will take you away from this page, is that the June call we will talk about the new program instruction. We've been getting a lot of questions about that, and we also will give you more information about the CIP meeting August 29th and 30th in Washington, D.C., and we will have a draft agenda out prior to that call. So that's the call on June 21st at 2 o'clock Eastern. And then with my last minute, I will tell you that if you go to the left-hand side of your screen, in middle of the screen, you will see doodle poll for APPLA older youth provisions. If you click on that link and you hit browse to, it should open the doodle poll directly in your web browser, thereby eliminating the need for us to send an email out to the CIP listserv. So yes, an ambitious agenda. I want to again thank our presenters on today's call and also let you know we are very excited about launching this next community of practice, and I will speak to many of you beforehand, but hopefully all of you again in June. So thank you so much to the Center for Courts team and the presenters and everyone for your participation today. Thank you.